Cameron Phillips is a senior associate at Ulrich, Roux and Associates, joins me now live for a discussion on this matter. Very good afternoon to you, Cameron. Thanks very much for your time. Just on the back of what Advocate Toby said there, I have to start here. The issue here is perhaps less about whether and what alternatives are there, but the argument, in essence, is procedural, is procedure. In other words, the argument that is that here is that the hike was adopted without proper parliamentary oversight or proper procedures being followed. Am I correct?
Afternoon, Vuyo. Firstly, thank you very much for having me. You're quite correct. And I think what's important to really start off with is the actual premise of the two applications before this court. The application by the DA is founded in two parts, Part A and Part B, with Part B relating to the constitutional challenge to Section 7(4) of the VAT Act. But Part A of this application is this urgent interim interdict that's currently serving before the court. The EFF's application is seeking a similar order, but also seeks to intervene in the main application sought by the DA.
What, though, will they have to prove in both those instances for them to stand a chance of seeing their application succeeding?
Well, you would have heard me refer to the fact that they're seeking an interim interdict, and the interim interdict that they're seeking is 2 points, really. One, that they're seeking the setting aside of the adoption of the framework, which has been recommended or which has been adopted by the National Assembly. And two, the suspending the operation of the Commissioner of SARS ability to collect on the increased VAT. Now, what they are seeking is in the form of an interim interdict. And on an urgent basis to seek an interim interdict, there are 4 requirements which have to be clearly met and made out before the court. The first one being a prima facie right open to some doubt, a well-grounded apprehension of irreparable harm, the balance of convenience in favor of the applicant, and a lack of suitable alternative remedies available to the applicant.
Could it succeed or not on the basis if, let's say, the urgency is not proven or demonstrated?
Well, I think it's a very interesting point that you ask surrounding the urgency, and you're quite correct. In any urgent application, the very first leg you have to meet is proving to the court that your matter is so sufficiently urgent that it warrants jumping the queue and being heard right now. If I go and read the answering affidavit deposed to by the Minister of Finance, there's very little made about the urgency of the matter. In fact, it seems that he effectively concedes there in his affidavit that the matter is, in fact, urgent. And I think the reasoning behind it is quite simple. It's because the operation comes into effect in very short order, being the 1st of May. If we turn into the requirements themselves and what they have met, the DA has made out quite a detailed case for the requirements for an interim interdict. And I think that they have made quite a succinct argument in respect of the well-grounded apprehension of harm. I mean, if we look at it, it's very, very readily apparent what the harm is to be suffered by the general public in the event that this VAT hike is implemented. The balance of convenience, I do believe, is in favor of the applicant. And in terms of lack of suitable alternative remedies, there has been approaches to the minister to already stop him from implementing the VAT hike to this stage, all of which have effectively been refused or alternatively ignored. I did an interview last week surrounding the first requirement that I referred to, being the prima facie right open to some doubt. And at that stage, I held a view that the DA hadn't really made out a solid argument in that regard. But having reread the founding affidavit of the DA, the right that they are referring to is they're protecting the right of citizens to be taxed without representation. And I do believe that there is a sufficient right, at least on a prima facie basis, for interim relief to be granted. And what's very important to note is the nature of the relief is interim. They're not seeking for a final interdict at this stage, the requirements for which are much more stringent to meet before a court, especially on an urgent basis. And it's pending the outcome of a constitutional challenge where the very public stands to be affected in the event that there's not an adequate determination. So having considered the papers filed at this stage and having listened to some of the limited argument by the counsel for the various parties, I do believe that there is a ground, or at least a basis, for an interim interdict to be granted.
You went, I think, where I was going to go next, because their chief whip was trying to, the Payne's trying to explain this morning, saying this is not just about the VAT, the 0.5, or the fiscal framework that Parliament did adopt, but also it's about the ability, or shall we say inability, of individuals to feed their families, pay their bills, find a job. To those issues that the DA has put before the court as part of its arguments matter in this instance, or at the stage even of this case?
Well, indeed so, because you would have noted that I mentioned the requirement of a well-grounded apprehension of harm. Those very much tie into the merits of the application. If you are intending to interdict the operation of the operation of the VAT hike on the premise that there's an apprehension of harm, then you most certainly have to make out an argument, and a sufficient argument to that effect, to demonstrate that there would be harm that would be experienced, and that harm would be irreparable. Given the fact that a large amount of South Africans live in poverty, it's in my mind, it's very readily apparent that the harm is irreparable.
Now, the Speaker of the National Assembly, in the arguments, essentially says the DA is trying to get here what it lost in arguments, discussions, deliberations in Parliament. It is trying to now get that via the courts.
I'm sorry, you broke up a little bit there.
Oh, sorry. I'm saying the Speaker of the National Assembly essentially is arguing that all that the DA is trying to do here is get via the courts what it lost in arguments, debates and deliberations inside Parliament.
Well, the DA's version in that regard is that the report was adopted by the National Assembly. But if we read further into the affidavit deposed to by Ms. Helen Ziller, you'll note that there is averments and allegations made that the recommendations made in there, whilst they were adopted, were not necessarily accepted. And that's really the reliance placed upon by the DA in terms of the unlawful adoption of the resolutions, is that, yes, the report was adopted by the National Assembly, but the recommendations in there weren't adequately accepted, which is what is required in terms of the relevant legislation.
And the Finance Minister, on the other hand, says, well, this increase cannot be stopped at this stage.
Well, I mean, if we go and look at what has transpired at this stage, the Finance Minister's version is, I gave a recommendation, it went through to Parliament, there was a resolution adopted, and now the framework is to be implemented. If we look at procedurally what the versions of the various parties are, I think we are in the correct place at this stage. The only way that it is going to be stopped at this stage is by an order of the High Court preventing it from being adopted. We have a version of the DA, which says there was non-compliance with the requirements to adopt the resolution. And we have a version by the Minister, which is directly to the contrary.
Do you want to call it, Cameron?
If we had to look at balancing the interests of justice at this stage, there is little harm in my mind, or little prejudice that the fiscus can or would suffer that would outweigh the harm that the general public would suffer. If I had to be a judge sitting with this matter, and frankly, I don't think that's an enviable position to be in. I would say that it's more in the interest of justice to grant the interim interdict, pending the outcome of the challenge to the provisions of the VAT Act, as well as the remainder of the main application.
Grant, Cameron, Phillips, thank you very much for your time and the insights. Senior Associate at Ulrich, Roux and Associates.